Are you taking the solicitor's qualifying examination? If so, this video is a practice test to help you prepare for the SQE 1 exam. The topic tested in this video is the rules of statutory interpretation. I will explain what you need to know for this subject, which I've set out in this easy to learn diagram. We will then go through this practice test question together from the SQE 1 exam for this topic. To get the first part of my full SQE preparation course for free, just click on the link below. My goal is to help you prepare for and pass the solicitor's qualifying examination first time. Let's start with what you need to know for the SQE 1 exam about statutory interpretation. There are several rules of statutory interpretation which form part of the SQE curriculum. The literal rule. The starting point in statutory interpretation is to interpret a statute according to the literal meaning used in the statute. This is its natural, ordinary meaning. The use of the literal rule is illustrated by the case of Fisher and Bell. It was an offence under the Restriction of Offensive Weapons Act of 1959 to offer certain offensive weapons, including flick knives, for sale. The defendant had displayed a flick knife in his shop window with a price tag on it. However, in the law of contract, doing so did not technically amount to an offer, but rather an invitation to prospective customers to make offers to buy it. For this reason, the defendant was ultimately not guilty of the offence. Parliament had to subsequently bring in a new law specifically to make a display of flick knives in a shop window an offence. This illustrates that interpreting the law literally, giving a word its natural and ordinary meaning, will not always produce the result that Parliament had initially intended. This is the principle that courts should interpret legislation so as to avoid absurdity. If applying the literal rule leads to absurdity, then the so-called golden rule enables a judge to modify the literal interpretation, the plain and ordinary meaning, so as to avoid such a result. How would this work in practice? Well, in the course of a hearing, legal submissions would be put to a judge as to the exact meaning of a particular section of a relevant statute. When ruling on this issue, the judge would first consider the natural, ordinary meaning of the words used. If this would produce absurdity, then the judge would interpret the words in a different way, which does not result in an absurd meaning. In Adler and George, the Official Secrets Act 1920 was considered. This made it an offence for an unauthorised person to be in the vicinity of a military base. The court had to consider whether a person inside, as opposed to in the vicinity of, a military base was guilty. This was the ambiguity in the case. The court held that the individual was guilty of the offence because the contrary reading would produce an absurd meaning. In other words, that someone could be in a military base without being in the vicinity of it. A further example of the golden rule is the case of R. and Allen, in which the defendant was charged with bigamy under Section 57 of the Offences Against the Person Act of 1861. This made it an offence to marry while one's spouse is still alive and not divorced. The court held that the word marry could not, in that context, mean become legally married, since that could never apply to someone who is already married to someone else. So no one could ever commit the offence under this interpretation. So to make sense of the provision, the court interpreted the word marry to mean go through a second ceremony of marriage. This meant that the offence of bigamy was committed when someone went through a second ceremony of marriage rather than legally marrying, which was not even possible. This is the principle that the courts should interpret a statute to give effect to clear parliamentary intention. This means that an ambiguous provision can be interpreted in light of the stated intention of the Act. When such a position arose, Lord Pentland stated in the Botterill case, counsel acknowledged an unattractive position, that there had been drafting errors, as a result of which the intention of Parliament had not been faithfully reflected in the language used in the statutory provision. If strictly read, the court was powerless to deal with the problem. In my opinion, this argument is unsound because it fails to acknowledge that the court should not only construe legislation so as to avoid absurdity, but also, and more generally, so as to give effect to clear parliamentary intention. The mischief rule. The mischief rule asks what problem or mischief the statute was intended to remedy, to cast light on the meaning of a particular provision. It permits the court to consider what the law was before the statute was passed, what mischief or problem that the statute was supposed to remedy, and the reason for such a remedy. Such information may be apparent from the recitals within an Act of Parliament itself and, for example, in the explanatory note accompanying it. When interpreting the meaning of particular statutory provisions, the courts will make certain presumptions about the law. These presumptions will apply unless rebutted by statute. The main presumptions are a presumption against change in the common law. It is assumed that the common law will apply unless Parliament has made it plain in the Act that the common law has been altered. A presumption that mens rea, guilty mind or intention, is required in criminal cases. Mens rea, the intention to commit the offence, is usually an essential element of an offence. There is a common law rule that no one can be convicted of a crime unless it is shown that they had the required intention to commit it. There are certain exceptions called strict liability offences, where no mens rea needs to be shown, but these will generally need to be highlighted as such in an Act of Parliament. A presumption that the Crown is not bound by any statute, unless the statute expressly states. A presumption that a statute does not apply retrospectively. No statute will apply to past events. Each statute will normally only apply from the date it comes into effect. This presumption can be rebutted if Parliament chooses to pass a statute with retrospective effect. Aids to statutory interpretation and construction. In addition to these presumptions, there are various other aids to statutory interpretation and construction. The Interpretation Act, 1978, has various provisions that govern statutory interpretation. For example, Section 6 states, unless the contrary intention appears, words importing the masculine gender also include the feminine, and words importing the feminine gender also include the masculine. Section 3 of the Human Rights Act, 1998, states that as far as it is possible to do so, an act must be read and given effect in a way which is compatible with the rights in the European Convention on Human Rights. This only applies to any case where there is an issue of human rights. Intrinsic aids. Intrinsic aids are features of an act itself, such as the interpretation sections, titles, preambles, headings. Extrinsic aids are external sources which may help put an act into context. An example is Hansard, which is the official report of what was said in Parliament. The case of Pepper and Hart permitted Hansard to be used where legislation is ambiguous or obscure. So, in summary, you have 4 key principles of interpretation where a question of interpretation arises. You have the literal rule, This gives the words their natural and ordinary meaning, that is, their literal meaning. Then the golden rule. This gives the words a different meaning, where a literal reading would result in absurdity. You then have the purposive approach. This examines Parliament's intention to find the meaning of the words. You then have the mischief rule. This asks what problem or mischief was the statute designed to remedy. Here is a sample question from the SQE for this topic. In the course of a trial, various arguments are put to the judge as to the exact meaning of a particular section of a relevant statute. When deciding the case, the judge first looks at the natural, ordinary meaning of the words. However, such an interpretation of those words results in an absurd meaning being given to the section. The judge, therefore, in coming to his decision, interprets the words in a different way, which does not result in an absurd meaning. What method of statutory interpretation has the judge used? A. The literal rule. B. The mischief rule. C. The extrinsic evidence rule. D. The golden rule. E. The intrinsic evidence rule. The answer is D. The golden rule. So let's go through these possible answers. A. The literal rule. No, we are told here that the judge is using a different interpretation because in this scenario, the literal, i.e. natural and ordinary meaning of the words would result in absurdity. B. The mischief rule. No, there is no mention here of the judge having to look behind the statute at the mischief which Parliament intended to remedy when making the law. C. The extrinsic evidence rule. Again, no, there's no mention of the judge referring to an external source for help in interpreting the provision. E. The intrinsic evidence rule. There is no mention of intrinsic aids being used here, i.e. of a judge referring to the interpretation sections, titles, preambles or headings, for example. D. The golden rule. Yes, we are told that the judge, in coming to his decision, interprets the words in a different way which does not result in an absurd meaning. This is what the golden rule is intended to do. I hope you found this helpful. To get the first part of my full SQE preparation course for free, just click on the link in the description below. In that course, we go into a great deal more detail and provide everything you need to know on this subject to pass the SQE exams first time. See you in the course.